Good morning, everyone. This is John Cornwell. I'm the marketing director here at Plunkett Cooney, and it's my pleasure to help out on today's program. We are going to be talking today, of course, about workplace investigations, which, as we all know, can sometimes be like an impenetrable labyrinth to navigate. So we ran with that theme for today. Joining us to guide us through that labyrinth, if you will, is a co-leader of our Labor and Employment Practice Group, Christina Coral, who is in our Columbus, Ohio office. And before we get started, I'd like to just take a few minutes to give you some info about the firm and about Christina. For those who don't know, Plunkett Cooney is based in Southeast Michigan and is one of the Midwest's oldest and largest law firms with 130 attorneys. We have offices in 7 Michigan cities, as well as in Chicago, Illinois, Indianapolis, Indiana, and of course, Columbus, Ohio, where Christina is from. Our employment law practice group includes more than 20 attorneys who focus their practice primarily in the areas of traditional labor law and in employment liability and litigation, human resources consulting as well, and of course, investigations. Today's webinar has been approved for 1.25 general recertification credit hours through the HR Certification Institute and 1.25 professional development credits through SHRM. Following today's program, a certificate of completion will be emailed to each of you reflecting this credit. If you don't need the credit, simply disregard the certificate. And with that, I would like to introduce today's speaker, Christina Coral. Christina is a partner in Plunkett Cooney's Columbus, Ohio office and a co-leader of our employment law practice group. She has extensive litigation and trial experience defending employment cases in state and federal court. She represents numerous employers and has the distinction of serving as special counsel to the Ohio Attorney General for employment matters involving in several academic institutions, including the Ohio State University. And just for a quick housekeeping notes on today's program, and I'm going to turn it over to Christina right after that. For the Q&A portion, we're going to use our questions area on your heads-up display on your dashboard there. So if you could find that, you can type in questions throughout the program, and what we'll do is at the end, I will ask as many of those questions as time permits. But Christina is going to be covering a lot of information, so we want to keep things rolling. So again, look for that questions widget on your dashboard. And finally, I want to mention that today is presentation is being recorded. So when we're asking questions, keep them kind of general if you can. We don't want to identify anybody individually or companies by name, et cetera. So we're going to have that recording hopefully available later today on our event page, which can be found at plunkettcooney.com. So if you'd like to listen to this again, we also have the handouts there as well. If you have any colleagues that may have missed today's program, you can just send them that page link and they'll be all set. So with that, I will again thank everybody for being here today, and I'll turn things over to Christina.
Thanks, John. Welcome, everybody. Good morning. Thank you for coming to our webinar today. I was just telling John, this webinar is so topical because I literally today, after 30 years of practicing law, I have more open employment-related investigations than I've ever had in my career. I currently have 6 open investigations, which is really unheard of. And I think for all of you out there, you're probably experiencing some of the same things. We know in my education practice that this time of the year, when students are coming back to school, usually lead to more complaints. But the other thing is the fact that folks are going back into the office. And folks that are going back into the office realize how much they dislike all of their coworkers that they haven't seen for the last couple of years when they were working from home. And so I think what's going on right now anyway, as people are becoming acclimated back to the office, that we just have a spike in employment-related complaints. So hopefully this webinar today will give you some tools to deal with the storm that's coming your way with respect to workplace investigations. So let's go ahead and get started. So investigations have become a commonplace in the workplace now. everybody does investigations. I remember 30 years ago when I started practicing, investigations were much less prevalent than they are today. But I think most employers and human resources professionals understand that in this day and age, you cannot can't sweep either investigations or allegations under the rug. And you have to deal with them in a reasonable and orderly fashion, and that's how we get to reasons to conduct workplace investigations. So some of the applicable laws that we deal with when we're looking at conducting these, and John, you can go to the next slide, when we look at the overlay of all of the various state and federal statutes that necessitate investigations. We have your local Elliott Larson Civil Rights Act, which is the Civil Rights Act in Michigan. There's a similar state act in Ohio called the Ohio Civil Rights Act. We have Title VII, which most of you are familiar with because that's a federal statute that controls employment discrimination at the federal level. Then we have all of the, smaller subject matter statutes, the ADEA, which prohibits age discrimination, the state law, your new state law that regarding disability discrimination, and then obviously the ADA, the big one that prohibits disability discrimination at a national level. So how do investigations fit into an employer's overall administration of human resources in the workplace? Well, investigations occupy sort of a unique position when we're analyzing employment discrimination claims, at least at the federal level. And that's because under federal law, the United States Supreme Court has passed judgment on multiple cases in which it was held that employers can actually shield themselves from liability even if there was employment discrimination, including harassment, if, and we can go to the next slide, if that employer exercises reasonable care to prevent and promptly address any harassing or hostile behavior, and the employee unreasonably fails to take advantage of preventive or corrective opportunities. So what in the heck does that mean? That means you better have a darn good policy. So the idea with employment discrimination, harassment, any sort of discrimination policies is that not only do you prohibit the conduct, but you also include in that policy very detailed instructions about what employees are to do if they've experienced behavior in the workplace that they believe is violative of the policy. So what does that mean? That means that you have a roadmap in your policies telling your employees what to do if they believe their rights have been violated in the workplace. You can go on to the next slide. So this is the language, the type of language we're looking at in these protective policies. Individuals who believe they have experienced conduct that's contrary to the policy. You give them a roadmap about how to bring their complaints. One of the things we always keep in mind and that we find in many cases is that, don't forget, sometimes the employee's direct supervisor is the employee that's being accused of misconduct. So you need to address that in your policies and make sure that you provide an avenue or a procedure for employees to go around a direct supervisor to make their reporting in the situation that the direct supervisor is the one who's being accused of misconduct. So never forget to have that in your policies. You can go to the next slide. And then this is just, continuing policy language. Remember, you want to have policies in place that encourage your employees to bring forward allegations, because you cannot solve problems as employers if you don't know that they exist. So this type of language in a policy is very important to encourage your employees to come forward and to make sure that they know that retaliation for them coming forward will not be tolerated in the workplace. Additional policy language, you need to make sure that you're noting in your policies that allegations of harassment, discrimination, or retaliation will be immediately and thoroughly investigated, and any misconduct will be dealt with immediately and accordingly. So, back to the case that we were talking about, the United States Supreme Court cases. So the first step in having a defense to harassment or discrimination claims is that you have this ironclad policy that prohibits the behavior, that gives an employee a roadmap as to how to report suspected misconduct, and then outlines a method by which those complaints will be adjudicated. That's step number one. Step number two is that you actually follow through on what you've promised your employees you will do, which is conduct a thorough, prompt, and fair investigation. So the way we do that, take complaints seriously, right? You need to, and everybody knows, I am positive that every person in this webinar can identify one person in their workplace who is considered a chronic complainer that is never happy with anything, and it never fails that those complainers come forward with complaints, and sometimes they end up being legitimate. So you have to be very careful when you're analyzing the complaints as they come in, that you're not just ignoring complaints because they are coming from a serial complainer in your office. Then we get to the situation that all of us in human resources have been confronted with on more than one occasion, which is an employee comes to you and says, I just want you to know this. I don't want you to do anything. I don't want you to investigate. I don't want you to take any action, but I just want you to know this. And then they tell you about some situation in the workplace that may or may not violate your company policy. So what do? Do you just put it in your memory banks and move on? Or do you conduct an investigation? And John has already anticipated the answer and went to the next slide. The answer is yes. You need to do an investigation. We always think about this as the worst case scenario. If you have a complaint come in, even if it's from a serial complainer, we always think worst case scenario, which is what happens if we don't investigate this and don't take any action. So depending on, the nature of the complaint, be careful what you wish for, right? If you don't investigate and don't take any action, it certainly is possible that the same thing is going to happen again in the workplace and or happen to someone else. So the last thing you want is to have, for instance, a woman, I'm just using this as an example, a woman come forward and say that she has been sexually harassed by one of her coworkers. She asks you not to investigate, or you don't investigate and take no action, and then 6 months later you have 4 more women come forward and say that they have been sexually harassed too. And now where are you? You had noticed that this was going on and you did nothing about it, and now you have 4 more complaints. So that's just an illustration of what the worst case scenario could look like if you aren't thoroughly investigating the complaints as they come in. Okay, so we have a complaint. We've decided we're going to investigate it. Who should investigate? So I understand that there are many folks out there that have fabulous human resources directors. Our college and university folks have fabulous Title IX coordinators, and many larger organizations have a structure in place that they can handle their own internal investigations. And there's absolutely nothing wrong with that. You don't always need to bring in a lawyer in to do your investigations. Now, I like to eat too, so I'd love it if you hired me. but you don't have to. If you're not going to hire an outside investigator, though, there are really some things that you should keep in the back of your head to make sure don't get you in trouble in the future. First of all, who is doing the investigation? So, for instance, you don't want the direct supervisor of the two people that are involved in the complaint to do the investigation. That's because of several reasons. First of all, the employees might not feel comfortable telling their direct supervisor the full truth and nothing but the truth about what happened. The second issue is many times the supervisor is going to be imposing the discipline, right? So you don't want the investigator to also, as an example, you don't want the jury that decides the facts in your case to also be the judge and assign punishment. So it makes a lot of sense to have a much more neutral investigator do the investigation, make recommendations, and then the direct supervisor's role would be to implement discipline or training or something like that. And then you don't have to worry about having the, judge and jury operating in the same realm. We can go to the next one. These are just some more reasons why folks in supervisory positions probably shouldn't be doing your investigations. And we can go to the next slide. And here's what we talked. I got way ahead of myself, didn't I? And a supervisor might need to make discipline decisions following the investigation, so they should not be both the investigator and the discipliner. We can go to the next slide. So considerations when you're selecting someone. There's a lot of focus today, especially in academics, on training of investigators and making sure that investigators have experience and training regarding the subject matter and how to, actually conduct good and accurate investigations. And in fact, we're going to have an example here at the next slide. Courts have reversed investigation findings where investigators are inexperienced or untrained. This is what one court actually said. They invalidated an investigation and the discipline that came from it because the investigators were not trained, and the court found that it actually tainted the results of the investigation. This is the same case. The investigators didn't reveal the name of the complaining employee to the accused, did not disclose particular allegations, and did not make any documentation of the interviews that they conducted. So let me talk for just a moment about confidentiality. And I know it's sort of a hot topic in Michigan over the last couple of weeks, because there's been the release of the Coach Mel Tucker investigation report, and the name of the university vendor who made the allegations against the coach have been disclosed. So it's sort of a hot topic today. I've gotten a lot of questions about that. And the topic is, to what extent can you keep your internal investigations confidential? And we're going to get into this a little bit more later in the presentation. But the reality is, beyond anything outside of your investigation, you pretty much have to tell the employee who has been accused, who is accusing him or her, and of what. And the reason for that is, it sure is hard for someone to respond to allegations if they don't know what the allegations are, right? We can go on to the next slide. So my advice always is, I know sometimes folks don't want their identities revealed within the course of the investigation, but that's a pretty darn hard thing to accomplish. At the beginning of these investigations, you almost always have to disclose to the accused employee who is making the accusation and what the accusation is. So then we proceed on to our investigation. Review your handbook. You need to know what your policies say as an investigator, in order to know whether the facts that you will uncover in your investigation actually constitute a violation of policy, right? If you don't know what your policies are, how do you know if they've been violated? So get your preliminary facts, what happened, look at your policies, decide who's going to conduct the investigation, decide what documents and records need to be reviewed. I mean, sometimes folks have text messages. We know a lot of times that employees are friends with one another on social media, so they're interacting outside of the workplace. Don't forget to ask for that kind of documentation too. And then you really should prepare a script for interviewing your witnesses. The reason for that is so that you don't forget to ask questions. So I did an investigation one time, and I interviewed multiple witnesses, and for one witness, I missed one question. Out of all of the witnesses, it was dozens of witnesses, I forgot to ask one question, and it ended up being the whole case. So that's why I always tell folks you should have a script. And in the script, don't forget to include admonitions about retaliation, because we sure see a lot of retaliation claims today that employees who have come forward and made complaints are being retaliated against by their supervisors, their coworkers. So always include in your witness interviews admonitions about retaliation. You can go to the next slide. There you go. So I've had people push back, but I always do it this way. I always interview the accusing or the reporting employee first. The reason I do that is because I want to know the full universe of all of the allegations that are being made, so that I am much better able to question witnesses and the accused employee about those allegations. Now, many times once I talk to the complaining employee and understand what the allegations are, I then go through and interview the accused employee and the witnesses. And many times I circle back to the complaining employee, because I want that complaining employee to also be able to respond to whatever the defenses or the statements that were made by the witnesses and the accused employee. So that's sort of how the order I go about putting together the interview process. Now, we all know, and I'm going to give you a caveat, we all know that every investigation is different, and you might have the best laid plans of mice and men, and it might run off the rails. But I will tell you something that was just reinforced to me about 2 weeks ago with another investigation that I just concluded. And that is, part of your job as an investigator is to listen. I'm going to say that again, because not all of us are good at this, especially lawyers. Part of your job as an investigator is to listen. And let me tell you what I mean by that. Many times when we get to the point of a formal complaint, there's history, and it's been going on for a period of time. And the employee who finally decides to complain feels like he or she has not been heard or has not been paid attention to. I conducted an investigation a couple of weeks ago. I spent a very, very, very long time with the complaining employee. I let him tell me everything he wanted to tell me, give me every document he wanted to give me. I interviewed every witness that he wanted me to interview. I concluded at the end of the investigation that there were not policy violations. In other words, the complaints were not legitimate. The complaining employee called me after I issued my investigation report to thank me that even though I found against him in the investigation, he was just really, really glad that somebody finally listened to him. So don't underestimate the effect that you can have as an investigator just by being patient and listening. Okay. So we have the investigation done, or we're in the investigation, and we're getting to the point that we're going to, getting toward our writing our report, right? So this is right. What happened? When did it happen? Who witnessed it? Is there an explanation for it? You want to cover all of those issues that you learn in your first year journalism class, right? Who, what, where, when, why. And then document, document, document. People ask me all the time, do you audio record your interviews of employees and witnesses? And I don't. I really don't have an explanation as to why I don't. I don't mind people recording interviews. I just never have, because at least back when I started doing investigations 20 years ago, people were much less involved in, videotaping themselves and putting their personal information on the internet. And I think recording just made people nervous. And I didn't think I was getting thorough and honest answers if I had my, tape recorder going while I'm talking to a witness. So I just have never done it. I take very detailed notes. But like I said, you can really do it any way you want. Things have sort of changed today. And I know lots of investigators that do audio recordings of their investigations and interviews. We go to the next slide. But you do, even if you don't record, you have to take detailed notes, because you might start on day one interviewing witness one. You think you're going to have 5 witnesses to interview. You end up interviewing 25. And then you're thinking back months in the past, trying to remember what a particular witness said. And it just makes it so much easier if you've got detailed notes of your interviews. What information should be in there? Exactly what was discussed. And I do this a lot. If I can write fast enough, I was telling somebody the other day, I wish my superpower was to be able to write as fast as I can think. Wouldn't that be awesome? Anyway, in my notes, if I can write fast enough to take down word for word quotes, I do that. I think it's extremely powerful and extremely effective in an interview report to be able to put what folks said word for word, and I quote it, right? So you quote it in your report so that the readers know that that is a word for word reporting of what was said during the discussion and the interview. You can go to the next one. Okay. So once you review your policy, interview all of your witnesses, your complaining employee, your responding employee, and look at all of their text messages and their emails and look at all of the documents, we're to the point that you're going to be writing a final report. So I set it up that I state at the beginning of the report what the subject matter is, right? On such and such date, employee X came forward and made the following complaint against employee Y. The investigation was commenced on such and such date and included the following: spoke to these witnesses, reviewed these documents, and went through all of that. What did each witness say? What was the response from the responding employee? What did all the witnesses say? And then once you've outlined everything you've learned, you get to your presentation of conclusions. So you have to understand what the purpose of your report is. I mean, many times as an investigator, I'm simply a fact finder. I'm not issuing discipline. I'm not, suspending people, anything like that. I'm simply a fact finder. Sometimes, though, you as the investigator do decide what the discipline will be or if there will be discipline. So that's also so your conclusion will include that, right? Number one, this is what I found, and I consider this to be a policy violation, for instance. With respect to the policy violation, the appropriate discipline is X. That would also be in the conclusion of your final report. You make recommendations for the resolution of your complaint. And we can go on to the next one. And then we start getting public records requests, right? For you governmental entities and public colleges and universities out there, then it leaks out and you start getting public records requests. So we talk about this a lot. So the dilemma is, let's assume that you found some very, very egregious conduct within your organization. What do? Do you keep the report confidential? You might want to do that to avoid adverse publicity, but at the same time, you might want it to be public, or you might want it to be disclosed within your organization, because it demonstrates that you take these issues seriously. You received a complaint, you did an immediate, prompt, fair, and thorough investigation, and here's the investigation report. So, if we want to keep it confidential, how do you keep it confidential? So the easiest way we've found so far is to have you hire an outside attorney. And you designate some 1 or 2 interior management folks to deal with the attorney. And everybody on this call knows where I'm going with this, because then we take the position that the investigation and the report itself are covered by the attorney-client privilege. You can go on to the next slide. You can always decide later if you want to disclose the report. I mean, if you take the position that it's attorney-client privileged, you can always waive that privilege in the future if it ends up being the best thing to do to release the investigation report. I tell you this because it's much easier to waive the privilege and decide to let the report become public than it is to try to claw that report back if you've inadvertently released it, or if it shouldn't have been released and you didn't think that situation through properly. So, these are some of the considerations that you want to keep in mind for purposes of going forward with your investigations and what to do with these investigation reports at the end of the day. Now, we do have special considerations for governmental entities. You have public records laws that are applicable to you that private corporations don't, but you're still entitled to claim the attorney-client privilege. So, you can certainly take advantage of the attorney-client privilege. You just have to be careful and do it right. So that's why it's important that if you've got a highly controversial issue, if you have an extremely serious issue, or if you have something that you think might go public, it's probably a good idea in situations like that to immediately reach out to legal counsel so that you're paving the way so that you have all of your options available about what to do when you reach the end of these investigations. And then one last thing about retaliation. A couple of years ago, retaliation claims were the number one type of complaint that was coming into the EEOC. And the reason for that is there are sort of different standards that apply in a retaliation context than apply in a discrimination context. So, for instance, if you have an employee who comes forward and says, I believe that I was passed over for a promotion because I'm a woman. In order for that claim to be actionable, there had to have been some actual adverse employment action. So in this case, there was, right? Passed over for a promotion. That's a tangible adverse employment action, like being suspended, being disciplined, being fired. Those are all adverse employment actions, and those are required to be proven by employees in order to maintain a discrimination claim. Retaliation claims are different. Retaliation is a much lower standard. So, courts look at the standard that courts look at is that would the ordinary, reasonable employee consider the action in the workplace to discourage him or her from making a report of discrimination in the future. That's the standard for retaliation. That can be anything from, I didn't get invited to lunch with my coworkers because they found out I made a complaint to Human Resources, to I didn't get invited to the happy hour, I didn't get the office that I would have ordinarily been entitled to, any sort of adverse action either by management or by other employees that would operate to discourage employees from bringing forward complaints. So think about this. Retaliation, I mean, it is a big, big deal in human resources law. The other thing that is added to the retaliation puzzle is that, as I said earlier, so many employees now communicate with each other on social media outside of work. And that's just more and more opportunity for snarky comments, snubbing people from activities, anything that an employee could use to state that they have been discriminated against. So keep in mind those two. You can go, okay, here, let's ask this question. An employee complains about her supervisor. The supervisor ends up being reprimanded following an investigation. Now the supervisor fails to respond to the employee's written requests, avoids her in the office, and has discussed her with other managers. There is no, see what I mean by this? There's no adverse employment. There's no, tangible adverse employment action here. She hasn't been fired. She hasn't had her salary cut. But this is enough under current law, these, not responding for a couple of days to emails when you respond to everybody else's emails the very same day. These are all things that have been held to be retaliation under state and federal law. One additional last thing, this happens all the time. You've done an investigation. You decided you're going to terminate an employee's employment, and the day before, well, this comes up in so many contexts. We see this in contexts like this. Somebody knows they're going to get fired, and what we see a lot is all of a sudden they want to go out on FMLA leave, right? Or all of a sudden they want to go on long-term disability or something like that. The answer to these questions is, if you had already put in place disciplinary action for an employee, for instance, let's say we found an employee stealing. You decided you were going to terminate that employee. The day you call him in to terminate him, he makes a complaint to you that he's been, discriminated against on the basis of his age, right? Can you still terminate him? You already decided you were going to terminate him before. The answer is yes, right? I mean, you've already determined that you were going to terminate this employee. And so then the question is, you terminate the employee who you now have a complaint from, right? But you're terminating him because you found that he was stealing from the company. And so you terminate him anyway because you were going to anyway. Do you still conduct the investigation? On to the next slide. Yes, you should still conduct the investigation because remember, anything that happens in the workplace is capable of repetition. So maybe this time a supervisor is allegedly discriminating against an employee on the basis of the employee's age. The older employee is now no longer working for you, but the supervisor could still discriminate against other older workers. So you need to make sure that you are addressing the behavior, whether or not either the subject of the complaint or the complaining employee are still with you. Okay, well, that sort of brings us to the end of the process for conducting employment investigations internally. And so we're going to move on to the dreaded Department of Labor audit. And frankly, this applies in lots of contexts. I mean, you don't want the Department of Labor investigating. If you're a college or university, you don't want the Department of Education investigating. You know, if you're smaller companies that are not subject to the jurisdiction of the Department of Labor, you still may be subject to the jurisdiction of the Commerce Department in your state or other state agencies that are tasked with bringing these types of investigations. And frankly, they're right now, wage and hour lawsuits are extremely popular. So frankly, right now, we've sort of seen a drop in some of the Department of Labor investigations because there are law firms that have become very good at targeting particular industries, for instance, the restaurant business, for minimum wage and overtime violations. And they've done a lot of advertising. And so we see a lot more wage and hour, Fair Labor Standards Act, class action lawsuits or collective action lawsuits than we've seen, in the recent past. So the effect of that is that there are fewer employees that are going to the Department of Labor with wage and hour complaints. And then we're seeing fewer and fewer Department of Labor investigations that are started with complaints that have come from employees. Now, we still have random audits. I just went through a random audit not a month ago with the Department of Labor that was literally random. They picked my client because it's a very large employer and decided to do a random audit. Everything turned out fine, but I had never had a random audit from the Department of Labor. So those really are the two ways that Department of Labor audits start. You either have an employee complaint or you have a random audit. And in the past, like it says here, an overwhelming majority of investigations in the past have been, based upon employee complaints. But like we said, we're now starting to see more random audits because employees are joining these class action wage and hour lawsuits and, frankly, making more money going that route. So what happens when you get a Department of Labor audit? Number one on the list, call your legal counsel. Sophisticated employers can probably handle a Department of Labor audit by themselves. But why do you want to? Why would you want to handle this yourself when you can call an experienced lawyer who's been involved in these cases before, that can, spearhead the communications with the Department of Labor and its investigators and the lawyers? Anyway, that's the lawyer plug. But the procedure, if you wish to handle it yourself, there's always an initial conference. And so what happens in the initial conference, it's typically just a telephone call with you and the Department of Labor investigator. And the investigator tells you what the allegations are, right? They hate putting stuff in writing. I can't tell you the number of cases I've had where I've had these huge Department of Labor audits. We get to the end of the audit that's lasted like 6 months, and the Department of Labor is like, see ya. And my client and I are looking around thinking, what's going on? Are you going to issue a report? Did you find any wrongdoing? No, we didn't find anything wrong. See you later. We're not going to issue anything. So they just, after all of that, they don't issue a final report unless they found some wrongdoing, and they just write off into the sunset, and there you sit. So that's actually a good outcome, but it's rather unsatisfying to have them not formally end the investigation with a writing. And in all of the cases that I've had, I don't know if it's different Department of Labor offices do it differently, but I've never had a final investigation report issued by the Department of Labor. Anyway, okay, so initial conference, you find out what the allegations are. They always tell you in the investigation, in the initial conference, what records they want to look at. So your next job then is you're going to go back, and I've done it multiple ways. I've invited Department of Labor auditors to come in and just sit down and start looking through our records. Now that so many companies keep things electronically, it's pretty easy just to download things on, a link, a share file link, or a thumb drive, and give it to the investigator, and then they can look at it at their leisure rather than in your office while you're standing there behind them looking over their shoulder. And then once they get all the documents they're interested in, they will let you know who they want to interview. And we'll get into employee interviews in a minute. I've only one time had the Department of Labor let me sit in on employee interviews. Usually it's not allowed. And then once the interviews are done and the investigation is concluded, the final step is this final conference, right? No written report, no letter, just a final conference on the phone to discuss the findings and potential penalties. The DOL has investigatory options, a limited investigation that they, so let me tell you why we're talking about this. This is what I tell everyone. The Department of Labor, in my experience, never just comes in and investigates the one thing they got a complaint about. The Department of Labor comes into your workplace and they want to see everything, not just the employee who complained, every employee that's in this class of employees, every record going back 3, 4, 5, 6, 7, 8, 9, 10 years. I'm just kidding. They only usually go back 3, but I've never had this first option that the DOL tells you is an option, the limited investigation. I've never had that. I've never had the DOL just come in and say, oh, we got one complaint. We're just going to focus on that one complaint. So keep that in the back of your head. Even if you think you don't have an issue with a particular complaint, keep in mind that the Department of Labor rarely limits its own investigation to just the one complaint that brought them there in the first place. Self-audit. I've never had anybody let me do a self-audit either. I mean, these are all options. They just don't happen very often. A self-audit is when the DOL comes in, they tell you what the issue is. They ask you to audit your records for self-compliance and then report to them about what you found and then go from there. I've never had that happen. And conciliation. I've never had conciliation. I just haven't. Without a formal, full-blown investigation. Now, at the end of a full investigation, I've had conciliations. I've never had one suggested up front. Okay. Anyway, this is your DOL audit defense. Like I said, have an attorney. Look at even if you don't want to have an attorney involved. Face forward with the Department of Labor. It's never a terrible idea to have an attorney come in and do an internal audit for you so you have some idea of what's coming your way, right? I mean, if you have some big DOL audit going on, don't you want to know what might happen at the end of the day? Many times, once you've been told what the issue is, I have clients hire me to come in and do my own audit and tell them what they might be facing. And then the other thing that does for you is at the end of the day, then you'll have your employees' finding or your attorney's findings and then the Department of Labor's findings that you can compare the two, right? So you can use your attorney's findings to either support or contradict the findings of the Department of Labor, and you may be able to use it to your advantage. We can go to the next one. Here's more information about, sort of taking matters into your own hands and doing, a defensive compliance audit. And the other thing to keep in mind is if you have an attorney come in, the attorney finds something that you're doing wrong, you can immediately fix it, right? Let's say you're somehow, for some reason, calculating overtime improperly. You can immediately fix that. And you can fix it retroactively. And then when the Department of Labor audit comes out, you can say to the Department of Labor, oh yeah, we already caught that and we fixed it. And this is how we fixed it. We fixed it going forward by doing this. And we've paid all the unpaid overtime or whatever it is going back the 2 statutory years. And, the hope is that then you will not be penalized. by the Department of Labor because you've already taken action to correct any problem. You can go on to the next one. These are the rules of engagement with the Department of Labor. They are the 600-pound gorilla, right? And you're not going to tell the Department of Labor what to do. They don't even have to tell you who's complained. And I've had that happen. I've had clients sued by the Department of Labor, and they don't even tell us in the lawsuit who is complaining. So it makes it sort of hard to respond. Then, when they interview your employees, you're not even allowed to sit in. Not only are you not allowed to contribute to the interview of your employees or to participate, you aren't even allowed to listen. So, this all is and the other thing they do is they'll just contact your employees directly. I think I've had, what I've considered a victory in the past. If I get the Department of Labor investigator to tell me who she wants to interview, and then I do the logistical arrangement for the interview, I consider that a win. Many times, the Department of Labor isn't even telling you who they're talking to. They're calling disgruntled employees. They're calling your current employees, and half the time your current employees just talk to them without even telling you they've been called. So, this all is, this is all very, it's all 100% controlled by the DOL. We can go on to the next one. And then if we get to the end, right, the end of the investigation, if they find that there's been some sort of violation, like I said, they can penalize you. They don't just have to let you pay the unpaid wage or unpaid overtime. They're entitled to assess liquidated damages, which can be triple, in some cases, the wages that are owed. I mean, I've had employers writing checks for $600,000, $700,000, $800,000 on some of these DOL audits. And that's just for the liquidated damages and the wages. Then they can fine you on top of that and collect fines and then enter into a settlement agreement. Or, as we know, the Department of Labor can also give the employees permission to pursue a private case, which is what we see a lot going on now because, frankly, there's just a lot of money to be made in these wage and hour cases. It's real popular to sue trucking companies, too, because over the past 10 years, there have been some changes to the wage standards as they apply to short range truck drivers, truck drivers that are not long haul, they're doing short routes. And some of these changes in compensation requirements were missed by trucking companies, and there was a whole slew of lawsuits that were filed because it's big money. Because if you have someone that you are supposed to be paying overtime to, even like 5 or 10 hours a week, that's no big deal. But then when you multiply that by 400 truck drivers, these numbers can get really big really fast. So these are some of the things to keep in mind for purposes of these Department of Labor interviews. I hope I helped you out with some of your internal investigation protocols and policies. But like I said, lawyers are your friend in this context, and we are always here to try to help you, whatever your employment problem might be. So, John, that's the end of my remarks. I don't know if we have any questions.
Well, we do, and that was awesome. So thank you very much. I hope you can catch your breath for just a minute. That was
my throat is sore.
Oh, get a drink real quick. Yeah, we do have a couple of questions that we can run through, and I just want to remind everybody that we're going to use the questions widget on your display there. So go ahead and find that now. We do have a couple questions in the queue, and the first one is: can you give a couple of examples of admonitions of retaliation?
Yes. Let me tell you my favorite one to use because people understand this. When I'm talking to witnesses and employees, this is what I tell them. You're a witness in this investigation. I know that you might have strong feelings about, whether you believe this person, you don't believe that person. You might think this is unfair or that is unfair, but your company has a policy against retaliation. And what that means to you is the cover-up is always worse than the crime. Retaliation is always worse than the underlying issue that's being investigated because people that might not have done anything wrong up to that point could end up being fired. And I think you just tell people, I know you're just a witness. You got to let the investigation play out to the end and not interfere because you could end up losing your job over something, the underlying of which you didn't even participate in. You just participated in the cover-up, which is the retaliation. So I try to put it in those terms for people because people seem to understand that. Because people know about cover-ups, right?
Yeah, we sure do. Yeah, great. There's another question here too, switching gears just a little bit, but it gets back to if you don't disclose a investigation report, what do you tell the complainant about the outcome or what was done, if anything?
Well, so what we do in cases that we're not disclosing the investigation report is I have a follow-up meeting with the complaining employee. I usually don't have the investigator do it. I'll have, a higher up in the company do it, maybe the director of human resources, probably not the direct supervisor, but you just sit down and you walk them through. And every now and then, I'll let a complaining employee look at the report, but not keep it. So those are your options. You sit down and go point by point through the report orally, or you can allow the employee to review the report, but not keep it.
Got it. Okay, a couple more questions, and we're going to wrap up. So if you have a question, now's the time to enter it. How do you prevent retaliation if you can?
You hire Christina Coral and everybody is afraid of her and they won't dare retaliate. Look, you can't, everybody knows you can't make people do what you want and you certainly can't make people do the right thing. All you can do is scare them. You just can't. You got to scare them. You got to scare them, just like I just said. You scare them into not retaliating.
Yeah, makes sense. Here's one that's interesting. If the accuser does not respond to multiple attempts to participate in the investigation, do you complete the investigation and close it out? It goes on. Then the accuser comes back later stating they want to participate in the investigation process now. It's almost like a delayed response. Are you required to reopen and meet with an accuser?
So let me answer the first question. Yes, and we have this happen all the time, and I really see it a lot on college campuses because we're dealing with young people, right? And young people don't always make the right decisions. So I always close out the investigation, and I document every single attempted contact. On such and such date I emailed, on such and such date I called. This investigation cannot go forward without the participation of the accusing employee, and then I say why. Because sometimes there are situations that you can investigate without the complaining employee because it's something that may have been witnessed by others, okay? Sex harassment, it's very hard to do that because people don't usually sex harass people in front of an audience, right? So I always close out the investigation, and I actually have had people come back like 6 weeks later and say, oh, I want to go forward now. And you know what? You're probably not legally obligated to do it. I do it anyway. I do the investigation anyway. What do you have to lose? Just you were going to do it 6 weeks ago. Do it now.
Right. Excellent. Okay, one last question, and this is kind of like a resource question, so you may not know, but is there a specific or formal training course maybe that you could recommend for HR pros about investigating?
Other than this one?
No, I thought this one was pretty darn good. Yeah, but I guess SHRM does a fabulous job training investigators.
there are actually some, you're going to think I'm weird when I say this, there are actually some police agencies that will allow civilians to take investigation courses. Oh. It's not always directly on point, but cops are really well trained in the who, what, when, where, and why. And cop training sometimes can be very helpful to investigators just for the nuts and bolts of how to investigate something and not necessarily the subject matter. But there are community resources that do investigation training. Just do a Google search.
Excellent. Yeah. I didn't know about the police station doing that or the cops doing that.
Some do. Listen, not all of them do. But there are agencies here in Ohio that I know will let civilians sit in on training.
Yeah. Okay. One last question looks like here. If an employee fails, if I could read, if an employee feels that the accused supervisor is showing signs of retaliation, what should be your first step to address the issue?
Well, the first thing you have to do is figure out what the retaliation is. I mean, you have to meet with the employee. You need to get absolute details about what the retaliation supposedly is. And depending on what it is, I mean, you might have to talk to the supervisor about it. The supervisor might not even know they're doing it, right? Mm-hmm. I mean, many times supervisors that get sort of put in a corner because they've been accused of something, shut down and just refuse to deal with the employee who's making the complaint. That can be considered retaliation, and they might not even know it. Mm-hmm. So, number one, find out what the actual allegations are, what supposedly happened. And number two, if it's enough that you think it could possibly be retaliation, you have to talk to the supervisor.
Got it. Okay, well, that wraps up all of our questions in the queue. And we are now into that second part of the hour, second hour. So I'm going to wrap things up if that's okay with you, Christina. I'll take it on home. Great job as always. I do want to mention too that we are going to be sending all of you a webinar survey. I think it's auto generated these days, so look for that. We would really love to get your feedback. In particular, if you have ideas for future training, we would love to hear from you. We're also actually planning on doing a seminar in the fall here a little later, and probably in November. We don't have the date pinned down yet, so we will definitely consider those topic suggestions if you can pass those along to us. So please, if you could, real short survey, let us know how we did today. The other thing I do want to mention is that the recording will be on our event page. Someone asked if we'll be sending the recording out. We don't do that, so if you could just check our website. We have an Insights tab there, and under that are all of our events. You'll find Endgame there. In the recording, I'm hoping to get that done later today. So look for that in the next day or two. This is also a great page to send to your colleagues that maybe missed, or if you want to come back at some point and refresh, it'll be there for you. We don't take those down. And they are on YouTube as well. We actually have a whole library of stuff out on YouTube. If you haven't found us there, I'd encourage you to take a look there as well. Also, we cover a lot of these issues on our blog, the Sophisticated Employer blog. There's an opportunity to subscribe just by popping in your email address, and then you'll get an email every time new content is added. So I encourage all of you to take a look at the Sophisticated Employer blog and sign up for that. And at this point, I think I've run out of stuff to say. Christina's exhausted, and we probably need something to eat. So thanks to everybody for being with us today. Christina, thank you for the pearls of wisdom, as they say. And we wish everybody a great rest of the day.